So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is, and so there's not going to be any change just because there's a new lawyer.
I've seen the tapes, and it's not enough on the tape to show that I deserve 8 years.
All right, but that'll be up to
trouble in 20 years.
That'll be up to a jury. That's what juries are for. You can go back with the bailiff.
Thank you.
Ms. Mouton, in cause number 25 DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there...
Did this in January 20th.
The competency report's from October.
You found her competent January 20th.
That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway, found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right. So in cause number 25 DCCR 0907, Ms. Mouton, you're charged with the second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25 DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25 DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony, from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently, and then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years for both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And you want to reject those offers and have your cases set for trial.
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, Listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released, and Miss Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change
Judge, I thought that was a very generous offer.
that you've reached just for a 5-year deferred probation? There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, and that would likely include mental health treatment so that you can stay on the right path and be able to be successful. Is that your understanding?
Yes, ma'am.
Also, that there would be a dismissal in clause number 25 DCCR 0170 as part of that. Is that correct?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And that'll just give me more information about you, your case, and that way also everything will be in place for you to have anything that you need as soon as you start your probation with regard to mental health or anything else, okay?
Yes, ma'am.
And so we'll see you back at sentencing. Okay, good. Mr. Rojas, you have Bethany Batten.
Yes, form the shift.
Bethany Batten.
This morning.
Oh, she's,
Oh, that's fine.
Okay.
Transported, yes, ma'am.
okay. We'll reset that. You have Relacia Mouton.
Those are rejections, Judge.
Relacia Mouton.
Morning.
Good morning.
Good morning again.
Good morning.
Okay, it's nothing.
There's 5 cases. I can do. Are both of those, Good morning. Are you, Caleb Laskowski?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Yeah, absolutely will, Your Honor.
Get that. Mr. Laskowski, in cause number 21-37917, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 3rd of 2022 for the offense of evading detention with a motor vehicle. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance February 16th of 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance on February 16th, 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample on March 29th of 2022 that tested positive for methamphetamines, amphetamines, and benzodiazepine. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample April 14th of 2022 that tested positive for methamphetamines and benzodiazepine. Is that true or not true?
True.
And then count 5 alleges that you were behind in your court assessed fees as of April 13th of 2022 in the amount of $315. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Laskowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, also find sufficient evidence to find you guilty, and at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being here.
Thank you, Ms. Smith. Yes, sir.
All right.
Steve, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you a few things.
Well, he's here, so we'll.
Hold on, Derek.
You can go ahead and bring him.
What's that, Judge?
You can bring him.
More.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number one, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What?
Over here, February 24th.
All right, so I've already made that
Found him
finding. All
competent.
right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity evaluation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him.
Okay.
I just need a little time to get that. The state, after I get that, then we'll move forward and
Okay.
yeah.
Do you think he can get that done in 30 days? He's already done the competency. I would
Well,
think he would be able to.
When he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from went out and did a competency
Right.
and then billed me. But then, so I was like, it's like, hang on a second. So,
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him and he'll maybe.
We'll do 30 days. And if you don't have that back, let us know right before that court date and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay. All right. You can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane,
Yes, Your Honor.
you've got Ahmad LeBlanc.
He's in custody.
What is this?
Ms. Malfino, Ahmad LeBlanc.
Sitting here thinking I could notice a nice young new probation officer.
All right, are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3, and a motion to adjudicate and on probation for possession of a controlled substance, first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have you? Any additions or corrections to the report?
None from defense.
Only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail in this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January the 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malfino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwa has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
No, ma'am.
So, Mr. LeBlanc, you've done so well. Better than most. You've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. If you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm not going to do that today. I think you've come a long way. You're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be You'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this was an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you, Ralph.
So we're gonna need this though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it filed into the case.
Thank you, Your Honor.
Yes, sir.
Yeah.
Hey, Judge Walker, you have Paul Nelson.
Yes, ma'am.
Paul Nelson.
Yes.
Have a good day. Doing okay?
Good, how about you?
2 days in a row.
I know. Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in cause number 23 DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 23 DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone.
Yeah.
State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he is indigent. If I need to, if the court needs me to inquire about that, I'm happy to, but he's been incarcerated for 2.5 years and he has zero dinero.
What are the typical court cost on a,
200 and something dollars plus this fee, plus that fee. So total in both cases, Your Honor, will be around $550.
what I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with a process for that, and take into consideration that he's indigent, that you've relayed that, and I will let you know
Thank you.
exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Mm-hmm. Mr. Lewis, you have Daryl Burnworth.
Yes.
Good morning.
Good morning, Jim.
How are you?
All right. Oh, that's it.
Good morning. Are you Daryl Burnworth?
Yes, ma'am. Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it's it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Ms. French at this time. All of his history is in Louisiana, so I just need to verify some things for.
Okay.
So if I can just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all, Your Honor.
All right. We'll reset it to either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff. See, Mr. Lewis, you have William Miller.
Yes.
William Miller.
And this is Mr. Coleman.
Yeah, I think he's the report came back incompetent.
Correct.
Good morning.
Good morning.
Since I hadn't, the only cases got reset, so like Tom would say.
That's nice of you. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller is charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley, and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial. and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With
nothing
regard to
else from the state.
competency.
No, Your Honor.
Nothing from the defense.
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the baby.
All right, thanks. Yeah.
Yes. Jamaldrin Willridge.
May we hold on that one, I think.
Okay.
That's
Sure. And maybe when the court has a couple minutes, maybe we'll just speak to you.
We're going to hold that for a second.
Okay, hold it. Thanks. Thank you.
Okay, we're going on. Let's see. Let me. Which, we're going on all of the counts, it looks like.
Yes, to enhance.
Do a third. It's gonna take me a second. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony November 8th of 2021. And after that was final, you were convicted of burglary of a building, a state jail felony June 26th of 2023. And how do you plead to that charge?
Yes.
And are those all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And I think
Okay, and then we have clause number 26 DCCR 0140. And, sorry, just a minute. And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the 2 from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
And then finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017 and also November 8th of 2021. So this one does not list those other priors, so it just is a state jail.
It's supposed to.
And I apologize, I didn't notice that it didn't list the other priors.
We don't object to an amendment if they.
Now, the state would ask to amend.
I'm not writing all that in.
Okay. You want to dismiss that one?
I mean,
That is the,
evading arrest or detention with previous convictions.
gosh, I hate dismissing and evading.
I mean, I can reset it. Y'all can file an amendment, or if you want to write it out, but that's too much for just an amendment. That's 3 prior offenses. So whatever y'all want to do. If y'all want to talk about it for a minute.
I can write them out if I need to be consistent.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it, and then I can read the the notice to enhance.
Okay, I'll do that very quickly.
I'll hold it.
Thank you.
We're ready, but we'll do another portion.
All right, Jameldrin Woolridge, Mr. Lewis, Ms. Malfino.
You're not worried about it.
Morning.
Good morning, Your Honor.
How are you?
Hanging in there.
Uh-oh. Those are albums, the last one. All right, are you Jameldrin Woolridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Woolridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Woolridge under my supervision until September 26th. Of last year.
Okay. And how has he done from then until he was incarcerated on this?
And he was very, cordial with me. We've had cordial bits of surprise by this and the other stuff that's been going on with it.
Okay. Any positive drug screens? Any issues at all since you had him in September?
Mm-hmm.
Okay.
May I just ask him one question for the clerk?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family?
That's correct. Yes.
With the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time.
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing
I believe he does, yes.
from your interaction with him?
Okay, well, Mr. Wilridge, this is tough for me. Because you've been given a couple of opportunities, and this would be another opportunity. And I don't know, I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you, right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand?
Mm-hmm.
You're going to be on 0 tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? All right, y'all can do the paperwork. Thank you, children.
Thank you.
Mr. Parker, you have Lloyd Calhoun.
Yeah.
Judge Parker didn't have this thing yesterday. I said, you better do that because she won't let you plead. What is that? I think they just haven't said, you have to have the attachment.
All kinds of new stuff's happened since he was up here, all the words I have to say. Good morning, are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, will the judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts, to make this a 3rd degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a 3rd degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a 3rd degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by a felon, July 8th of 2019. And are all 3 of those prior convictions true?
Mm-hmm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal in clause number 25 DCCR 1267, which is that tampering case. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you are serving time anywhere else or were anywhere else. Okay. So you'll get that credit. I'm going to, is it not printing? Okay. I'm going to hand you in just a minute a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So name it now.
You put the holes.
Well,
I think I probably printed it twice at least.
And this is, what I printed stuff for Pam a while ago.
Oh.
What I gave her wasn't all of it. Apparently we ran out of paper when I didn't know.
I printed some stuff also from that other case.
Okay.
I printed one for me, several things for myself.
Well, I think it's something.
Okay. All right. Here you go. You can go back with the bailiff.
No. Yeah. I mean, ask them every time. You understand. I tell you everything you're going to say. You have any questions? You understand everything I've gone over with you?
I know.
They always got to say something. I guess he understood. He didn't understood.
That's true.
Pam.
Oh, she probably wants to file that.
Well, help that copy I gave her.
Mr. Parker, you've got Patrick Trahan, 2 cases.
Patrick Trahan.
I can.
There's actually 3 cases. One of them being dismissed.
Judge, that was based on the fact that you just came back confident with trying to dispose of that situation, that window.
So, which one's being dismissed?
The 9-6. What I read the 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trexan is currently competent to stand trial. Any other evidence with regard to competency
No, Your Honor.
from the state?
No, no.
Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, Your Honor.
And are we going on count one only? On the assault on a peace officer?
Yes, Your Honor. We may need to go on both on the staging.
Okay, hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then just takes a minute for me to get it. And clause number 26, DCCR 0592, you're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Right.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here. Right, so I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And cause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those two prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those two cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in cause number 25 DCCR 1916. All right, you can go back with the bailiff. All right, let's see. Eric Tran.
More flash. I don't have any case. I just took comments without taking fire message. I played with everybody but you and Donovan. And then one of the comments got reset, one was in conflict.
So you guys safety, but I don't think you gave me credit for time served on the reckless.
Yeah.
Are you going to dismiss it, or is he going to plead?
Oh.
It was training.
These are rules.
Yeah, right. Okay.
I'll get them to do that. Is it set today? Do you know?
I don't know. They usually set it today, but
I'm asking.
Yeah.
I'm asking where it is. And I'll go to that.
is it here? We got two. Yeah, it's here.
Can y'all see my guy, now, it's paying parts, it's like, what's this meter and Facebook. What do you want, what's your misdemeanor, is it 2 to 3? You don't know. I mean,
Good morning, sir. Are you Eric Tran?
if you know.
And Mr. Parker, will your client waive the formal reading of the motion?
Here we are.
Mr. Tran, in cause number 22-40541, I have a motion to revoke your community supervision. It shows that you were placed on probation January 17th of 2023 for evading arrest or detention with the use of a vehicle, a third-degree felony. And that was a 10-year term in prison that was probated for 5 years. Is that correct?
Mhm.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of reckless driving November 28th of 2025 in Jefferson County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 10th of 2025 that tested positive for the byproducts of cocaine. And is that true or not true?
True.
And then count 3 alleges that you have failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation, but order that you enter and successfully complete the SAFE program. And then you would be back on probation and required to follow all of the rules and conditions. Is that your understanding?
Judge, that was the recommendation when I spoke with this officer, Georgie.
Okay, thank you, Ms. Malfino. And it looks like also you would enter a plea on that reckless driving for the time that you've already
I
served.
think you're going to get your credits. We're probably going to dismiss it, Judge. I mean,
He's got so much
Oh, okay.
credit that it probably technically easier to.
Yes, we're gonna resolve that today.
Let him go.
Okay, so then what I'm going to do, Mr. Tran, it sounds like everybody's wants to get you back on track, and that's what SafeP is for, so that you can have the tools necessary to be able to stay clean and do everything you're supposed to on probation. And so I'm going to follow the recommendation from probation and the district attorney's office. Find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke the probation, but I'm not going to. I am going to continue you on probation. I'm going to order that as a condition of that probation, you enter and successfully complete the safety program, and then follow all of the other rules and conditions of probation. If you do all of that, we should never see each other here again, and you'll be able to finish that probation or your time while you're out on probation. But you need to keep in mind, if you mess up again, you're going to be back here in court, and we're not going to be talking about the same type of thing. You'll end up going to prison. You've already agreed to a 10-year sentence.
Yes, ma'am.
Okay. Good luck to you, sir. You can go back with the bailiff.
Hey, do you want to, check my work?
See, Ms. Holmes, you have Edwinia Johnson.
Yes, Your Honor. It's a,
Plus the law perspective. I think it's like, I'm sorry. I'll check this out. Oh, well, thanks, I didn't do it.
They're for bond, right? We're not, or is she in her place on them, or just here for bond?
I did like that.
Thank you.
And I didn't know there was a bond set on it. Has she been a nerd of them?
Have two robberies, two into bringing therapy.
I've got one robbery.
Yes, one. It's, that's somebody else.
So,
Yeah, that's not.
well, we'll get turned off for that because of the name.
And so the request for bond are on the 3 MTRPs, correct?
Yes, Your Honor.
Good morning. Are you Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson's here, and cause numbers 24 DCCR 2151, 2152, 2153, and then there is also cause number 25 DCCR 1826. And the first 3 cases are all probation cases that Ms. Johnson is currently on, and there's been a motion to revoke filed in each of those. The underlying offenses are forgery, abandoning or endangering a child in the other 2, and then that new offense is for robbery. Ms. Holmes filed a motion asking for me to set bonds in those 3 underlying motion to revoke cases. She's on deferred, but I set it for a hearing based on that underlying offense. I want to know really what's going on before I figure out an amount or if I'm going to set bond. So Ms. Holmes, I'll let you go first. You're going to call your client for purposes of...
Yes, Your Honor.
Ms. Johnson, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
okay, you, Edwinia Johnson?
Yes, ma'am.
Okay, Ms. Johnson, how long have you been, in custody at the Jefferson County Jail?
It's in 8 days.
Okay, and, you're in there because you understand that there were motions to revoke probation due to, allegations that you violated probation, correct?
Yes, ma'am.
Now, the alleged offense of robbery is one of the underlying allegations. You're understanding of that, correct?
Yes, ma'am.
In which the offense date was not very long after you were placed on probation.
Yes, ma'am.
Okay. We've discussed that. While you have been in custody, we've talked about you trying, wanting to get back on track with probation, and while all of this is pending, correct?
Yes, ma'am.
Now, if the judge was to set a bond, where would you be residing? You don't have to give the exact address, but would it be in Beaumont?
It was in Port Beaumont.
Okay.
Either or.
Okay. And you have family who have obviously reached out to me who would be supportive of you to make sure that you come to any and all court proceedings, and that you do whatever is necessary, and that you understand that if you are given a bond, that there may be certain restrictive measures, such as GPS monitoring, things of that sort, placed upon.
Yes, ma'am.
Okay. And are you asking the court to set reasonable bonds in your cases so that you can hopefully be released and try to get back on track with probation? It doesn't seem that you got very far with starting probation because you hadn't been on it very long. Is that
Yes,
correct? Okay. And so you're asking for bonds to be set so that you can try to get back on track with that.
Yes, ma'am.
I'll pass the witness, Your Honor.
No questions.
All right, any other witnesses?
No, Your Honor.
Mr. Smith?
Judge, because they're deferreds, I believe that you have to set a bond. We would request those be fairly significant bonds. The underlying offense, even though it's not with strangers, it's people that she was living with. There was an argument, it turned violent. This defendant did not live there, but she was there. She gets in on it, holds her down while they take this other person's phone, ripped it right out of her hands. So this is 1 week after she went on probation in these 3 cases.
Last week.
Not yet.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probation based on that without some kind of significant cognitive treatment so that she would understand how to make better decisions. But we would request those bonds, like I said, to be significant.
So probation started in all 3 of these cases, October 6th of 2025.
Yes,
And so probation's here. And ma'am, would you raise your right hand, please? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And so were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation, and then again in November. But when the offense occurred, she then reported to me when I met with her in November. And that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first. So that was also another concern. And so there may be some compliance issues with that.
Okay. Ms. Holmes?
Well, Your Honor, being that she's on deferred, we would ask that a reasonable bond be set. I do understand the concerns of the department and the state, being that she wasn't on probation very long at all before the new alleged offense occurred. And with speaking with Ms. Johnson, she is realizing the severity of the cases that she is on probation for, and she has expressed to me that she wants to get this right and get back on track with things.
For the record, I'm reviewing at this time the probable cause in that underlying offense. Give me just a second, please. Who's taking care of your kids, Ms. Johnson?
My brothers and my sister and the boys are with their father people. Their side.
Okay. Obviously, it gives me a whole lot of concern that she was on probation for a week. Obviously, they're allegations, but they are serious and just shows a lack of concern for being on 3 felony probations. So I am going to set bonds, but in cause number 24 DCCR 2151, I'm going to set that bond at $50,000. And then I'll go over conditions in just a minute. Cause number 24 DCCR 2152 and 2153, set each of those at $25,000. Order as a condition of bond if it is made that there will be a GPS monitoring device and Ms. Johnson would be on house arrest. So I would have to know an address, who is living there, and she would be required to remain at that address other than visiting an attorney or coming to court, and be required to pay the cost of that GPS monitoring device, keep it on at all times, keep it charged at all times. Obviously have absolutely no contact or communication with Isis Martin, who I believe she's out, right? She was here yesterday. Smart sounds familiar. Anyway, and then also no contact with Harmony Boatner, and not to be at 901 Main, anywhere near that address in any of the apartments. Is that where anybody that you plan on living with lives? Okay, so you're not supposed to be, you won't be able to be obviously anywhere around there because you'll be on house arrest. But specifically, you cannot have any contact or communication with the co-defendant, with the complaining witness, or anybody that has anything to do with this. That means in person, but it also means sending messages or sending messages through other people or anything like that. Do you understand?
Yes, sir.
All right, we'll get it set for an announcement on the motions in the case then.
Yes.
All right, you can go back with the bailiff. Yeah, I guess probably, but it's not gonna.
Damn, like I could backslide them up, then I go look over before I get my bills. Judge, on this case with the court's permission, we're going to proceed on the lesser included. He has agreed to some stipulations that I would rather not put on the record. If the court can read between the lines on that.
Sure.
And also the co-defendant, for your information, was in custody in Orange County on a motion to revoke, I believe, a misdemeanor one. I've spoken with the prosecutor over there. It's my thought that probably Ms. Holmes let me know Louisiana has since picked him up, that they probably led him to credited time on that MTRP, and Louisiana grabbed him before we could grab him back. And that may ultimately dispose of the entirety of this case.
All right, sir, you're Devin Murray. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Murray, in cause number 26 DCCR 0346, the state's elected to proceed on the lesser included offense of robbery from January 15th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. have no contact at all, communication with the co-defendant, and that's Lugo.
Jesus Lugo.
Jesus Lugo. You understand?
No.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Murray's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser offense of robbery freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you in the case, and then we'll come back later for sentencing. So based on all of that, Ms. Malfino, what's the state's position with regard to a reduced bond?
The state is in agreement with that, Your Honor. He does not have any criminal history to speak of other than a possession of tobacco bond. All the criminal history is really associated with his co-worker, Mr. Lugo.
All right, so he's pleading.
No, I know, but
So, what I'm going to do, Mr. Murray, based on the nature of your plea agreement, is reduce your bond in your case to $1,500. If you make that bond, it is important that you understand a condition of that bond is to have absolutely no contact or communication with Jesus Lugo, and to do everything you're supposed to. Go straight to the probation department if you get released. Get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. If you get arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. So it's very important, if you make that bond, that you get out, you do exactly what you're supposed to, go straight to probation, and then we'll see you back here at sentencing. All right? You can go back with the bailiff.
No.
We started. And then the.
All right, Mr. Lewis on Jameldron Willridge. Oh, you just did paperwork on the new case? Okay. So is it the state's intention to dismiss the MTRPs?
With court's permission.
Yeah.
Whatever you prefer.
That's fine. No, I don't care which way we do it. If you want to dismiss them, that's fine, or we can go through them and I continue, but either way, it's kind of the same.
Okay.
All right. Again, you are Jameldron Willridge, correct? Speak up for me. And will your client waive the formal reading of the indictment?
He does, Judge.
Find it now. Mr. Willridge, in clause number 25, DCCR 1804, you're charged with the second-degree felony offense of burglary of a habitation from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow this agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement shows that this is for a 10-year deferred probation. What about, this is the one with the shoot. What about restitution? Right? This is the one where he went,
Yes,
it's all the shoot.
It was 100,
It was a lot.
probably 100 pair of Jordans. You would think I would know how much those cost.
So here's what I might do. just so that I have everything that I need, go ahead and get a pre-sentence report.
Okay.
You can get with them, get a restitution amount. You are going to be required to pay restitution. So if you still have some of the shoes, find them, get them, talk with Mr. Lewis. They can be returned, so you don't have to pay for them.
Okay.
He did get it all back?
I'll confirm
Okay.
that, Your
So we're going to just get that confirmed between now and then. And I do want to go ahead and kind of get an update so that the new case is in a PSI, since we don't have it, the new case. I don't need a little update on the probations, for sure, double check on ISF and how that went, but it sounds like there's not an issue, but I just want to make sure. And so, do you also understand, Mr. Woolridge, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your.
It's admitted. Is there any evidence Mr. Woolridge is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can just have everything in front of me that I need, make sure there's no other issues, and then we'll go forward with sentencing at that time. Any issue with me releasing Mr. Woolridge since he has been doing okay?
No, Judge, if wouldn't mind if I just hold on those MTRP dismissals until that sentence date.
I think that makes sense.
Pops up.
I think that makes sense. So, Mr. Woolridge, what I'm going to do in your case is reduce your bond to $1,000, but I'm going to make that a personal bond. What that means is that you don't have to pay the money. You will be released today. So what I need to do, though, is on those motions,
Unless it would make it easier for you if I just dismiss
just
it.
do personal. I can just set personal bonds on all of them. So I'm going to set personal. So on all 3 cause numbers that you're on probation for, which is 18-28743, 18-28744, and 18-30139. I'm going to set bonds on all of those where the motion to revoke are pending at $1,000 also, and make those personal bonds. So what all of this means is that you're going to get out today without paying any money. Some very, very important things, though, between now and when you come back for sentencing. Obviously, you're on probation still for the other 3. You need to report to probation for 2 things. 1, because you're still on probation. 2, so that they can do that updated pre-sentence report about the new case and kind of how things are going right now. Okay. If you don't go straight to probation when you're released to do all of that, then you run the risk of me not accepting this plea agreement. Things could obviously be much worse. Do you understand? Speak up, please.
Yes, ma'am.
Also, if you're arrested for anything between now and when you come back, you run the risk of me not accepting this plea agreement, and then you've got those motions pending, and things could obviously be a whole lot worse. You understand that as well? And so, was there a co-defendant in the burglary? Or no? Okay.
I don't think so.
So you do, I am going to order as a condition of your bond also, and it will be a condition of your probation, that you have absolutely no contact or communication with Jasmine Adams as the owner of that apartment. And that apartment was where? Do we have an address?
That apartment was located
I think probably get that. You said
4165 Old Dallin Road. It was apartment 91, but I would suggest
So,
you stay
yeah,
away from the
so-
entire complex.
correct. That's what I'm gonna do. So you cannot go anywhere near 4165 Old Dallin Road. Any of it, none of the apartments. Do you understand?
Yes.
Anything else that you feel like I need to order as a condition of the bonds?
I'm just double checking for any type of co-defendant. No, Your Honor, I don't believe so.
Okay. All right, then we'll see you back at sentencing. Again, make sure as soon as you're let out of custody that you go straight to probation. Okay. And then on Jabbar Bell, Mr. Parker,
Just to remind you, you did complete the first two, and the third one you started, we had to do the enhancements.
Okay.
He's already pled guilty, but you're just starting the enhancements.
Thank you. And so did it, it's probably not going to show up. Did you file that through?
I did not, Your Honor. I'm offering it in open court because it was agreed by defense counsel. I've given him an opportunity to review both the motion and the order, which I'll submit to the court at this time.
All right, sir, you're Jabbar Bell again, right?
Yes, ma'am.
And so we're back on cause number 26, DCCR 0274. And in that case, Mr. Bell, I'm going to start from the beginning in that one. You're charged with the state jail felony offense of evading arrest or detention with previous convictions from January 21st of 2026. And the indictment alleges you were previously convicted of evading arrest or detention March 13th of 2017, and then again November 8th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Now, Mr. Parker, the state has filed a motion asking to amend the indictment to include those two prior offenses that we've already gone through and read in the other tech cases. Do you have any objections? And you will waive your any time to review that, correct?
Yeah, Judge.
So, Mr. Bell, the indictment, I'm going to grant the motion to amend the indictment. Further shows now that you were convicted previously of unauthorized use of a vehicle, a state jail felony, June 24th of 2019. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And are those prior convictions true?
Yes, ma'am.
And in all three of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
Objection?
It's admitted in each case. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find in all of your cases that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. And cause number 26, DCCR 0139, find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find all of those prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, excuse me, in clause number 26, BCCR 0140, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find all of the prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26 DCCR 0274, again, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find all of the previous convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All three of these cases will run concurrently, which means together at the same time. And I'm going to hand you in all three cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under